this online lecture by Professor Gerald J. Postma, Professor at the University of North Carolina, USA. I would also like to extend a warm welcome to the Vice Chancellor, Professor Surya Prakash, and Registrar Dr. C.M. Rao and Director of Academic Affairs, Dr. Dayananda Murthy, and all our faculty members present here, and of course, all our. Now, all the attendees are requested, as Bhairav sir has said, to solve the questions in the chat box or in the question and answer session so that it can be taken up in the question and answer session time. To begin with the lecture, I would first like to ask our Vice Chancellor, Professor Surya Prakash, to give introductory remarks on this regard.
Thank you, Anirudh. Good evening to all. It's my privilege to invite Professor J. Postma. It's an online web series on this very important topic on rule of law. And I'm very delighted, and this would be very enlightening to all my students and also myself. And Viral, in your CV, I am very jealous of CV, your academic achievements, particularly your work on philosophy, and most particular about Jeremy Bentham and your volumes, his edited volumes on his works, and it's a very, very highly impressive. And all your works, and I'm very much interested to read more about philosophy, and as such, jurisprudence is my favorite area. Though I didn't work much, but still a fascination, and my students they introduce you in the most fitting manner. I don't want to read to that area. On behalf of DSNLU family, on behalf of my students, and on behalf of my faculty, and on my personal behalf, I welcome you to this webinar, and also grateful for sparing your valuable time to address my students. And undoubtedly, this is going to be an enriching experience to all my students and faculty. And speaking about this, and no doubt you are an authority on the rule of law and philosophy. And I am also very eager to listen from you your analysis of this rule of law. And undoubtedly, rule of law is the dynamic concept, and we are blessed democratic nations following this rule of law. Democracy and rule of law are two sides of the same coin. I think so. And the rule of law we have from Smith to that laws as enacted by Parliament be faithfully executed by officials, that orders of court should be obeyed, the individuals wishing to enforce the law should have reasonable access to courts, that no person should be condemned unheard, and that power should not be arbitrarily exercised. The democratic nations in following this rule of law, and rule of law may be considered as the foundation of democracy. The beauty of democracy is it is the people who are sovereign make the law for themselves, and they are governed by the law which they have made. So this is the beauty of democracy. That means everyone is a lawgiver and also the follower of law. So supremacy of law should be established. The success of democracy depends upon the people, the courts, the executive, everyone respect and follow the rule of law. And as far as India is concerned, we have and the most dynamic and most powerful document. This document, that is called the Constitution, is governing the 131.3 billion people. It's amazing. In large, the Indians, they are law-abiding citizens. 130 crore or 1.3 billion means that itself is a continent. So right, India is called as a subcontinent. So it is the diversity is the virtue of this country. How the rule of law is implemented, there may be certain aberrations that do happen when large population and so many religions, regions, inequalities of economic inequalities, disparity of many other differences. But in spite of that, one fact that is binding 1.3 billion people is the rule of law, that is the constitution, which is the goal of the Indian constitution, social, economic, and political liberty, belief and expression, and fraternity among all Indians. These are the cherished goals. And the law gives the spirit and every law that is passed by the parliament or by the state legislatures, they are compatible to the goals and objectives of the constitution. And even though we know the history of the rule of law, as Wade says that rule of law requires the government should be subject to law rather than the law subject to the government. As our Vedic text say that howsoever the law is above, including the king. Concept, and we have the directive principles, we have the fundamental rights, and so on and so forth. And this rule of law is implemented or understood in societies. The democratic society is concerned, they are the same that we follow the rule of law as it is regulated by the parliament or the legislative bodies. Few words. I once again welcome Professor Gerald Postema to address the students and the faculty and my student friends. It is a very, very great opportunity addressed by an eminent scholar, writer, who is an authority on jurisprudence, particularly the concept of rule of law. Sir, welcome you, and students, please listen carefully. If you have any doubts, needless to say that will be delighted by your questions and doubts. Thank you very much. Anirudh, over to Anirudh. Thank you.
Anirudh, you have to unmute.
Thank you so much for those introductory remarks, sir. And now I would like to call upon Shloka to give the introduction, brief introduction about Professor Gerald J. Postma.
Thank you, Anirudh. Professor Gerald Postma needs no introduction since his reputation speaks for himself. He has received several accolades and published many books on jurisprudence, which have summarized complex and diverse ideas in a concise manner. But in case anyone is unaware, here is a brief introduction. Professor Gerald Postma was the professor of philosophy emeritus in the University of North Carolina. He was a professor of law at UNC School of Law, the chair, Department of Philosophy, UNC School of Law, visiting professor at Yale University, and visiting associate professor at University of Michigan. He has been the recipient of the honorary doctorate, University of Athens, the George H. Johnson Prize for Distinguished Achievement in the Arts and Humanities, University of North Carolina. He has also been the honorary professor of Zhengzhou University Law School. He has given a keynote lecture on fidelity, accountability, and trust, tensions at the heart of the rule of law, conference on constitutional law and political philosophy in Curitiba, Brazil. And he delivered a keynote lecture in the Australian Society of Legal Philosophy, University of Sydney. He has also given the Leon Petraszki Lecture in University of Warsaw and the Boutwood Lecture in University of Cambridge. He has published a book titled Utility, Publicity and the Law, Essays on Bentham's Moral and Legal Philosophy. He has also published a handbook of legal reasoning and argumentation, which he co-edited with G. Bongiovanni. Sir, it is an honor to have you with us for the event, and thank you for gracing this occasion with your presence.
Anirudh, you have to unmute again.
A few words, Professor, for the session to begin.
You would like me to begin? Yes. Can you hear me all?
Yes, sir.
Yes, Professor. You're audible, Professor.
Okay. So, first of all, thank you so much for your warm welcome. I am very pleased and honored to have been invited to talk with you today. It's a delight to see each of you. I can see on the screen. Thank you for your warm introduction. I hope someday to be in your part of the world physically and not just virtually, to experience the wonders of Italy, of India. I am now, I call it imprisoned. I am held, locked into my house on the top of a little mountain, and it's quite lovely. So I'm not unhappy. But I do feel very much like I want to travel, and India is one of my most desired destinations. So thank you very much. Perhaps I should just begin with my lecture. So the idea that the term rule of law is usually more present to the minds of some lawyers than to the general public, and properly so. However, from time to time, that same term, that idea, surfaces with special intensity in the public as well, and this is one of those times. Let me give you a few examples of what I have in mind. First, from my home here in the United States. The first article of impeachment of our current president reads this way: the president has, quote, acted in a manner grossly incompatible with self-governance and the rule of law, close quote. This, of course, went through all the papers and all the news media, and suddenly we were, or gradually and then with great force, talking about the rule of law. Also recently, a number of prominent alumni, former members of the United States Department of Justice, called for the Attorney General to resign because of efforts he had taken to commute the sentence of a personal friend of the president. And just last week, on the 12th of October, two respected watchdog institutions in the United States, in a 267-page report, called for the Attorney General's impeachment for a wide range of activities. They said this Attorney General, the chief law enforcement officer of the United States, they accused him of, quote, treating the law adherence to the law as optional, using law for political ends, using law as a weapon against political enemies. All of this constitute, they argued, violations of the rule of law, and so grounds for impeachment. That call has not been answered yet. Of course, there are threats to the rule of law around the world. Many of them have been observed in, for example, Poland and Hungary and Brazil and Venezuela and elsewhere. I'm not competent to comment on the current conditions in India. I won't presume to do so. But I do know that in the late 1970s, a legislative challenge to the important principle of the rule of law, the principle that guarantees the right of habeas corpus, was considered in the case Jabalpur versus Shavakant Shukla. Perhaps you're familiar with that case, back in 1976. A vigorous invocation and defense of the rule of law ideal can be found in the dissent in that case by your renowned Justice Khanna. Later, Justice Khanna wrote a wonderful little essay entitled The Rule of Law. I'd like to take as my text for this lecture on the rule of law a passage from that essay. Here's what Justice Khanna wrote. There are three prime requisites for the rule of law: a strong bar, an independent judiciary, and an enlightened public opinion. And he added, there can indeed be no greater indication of the decay of the rule of law than a docile bar, a subservient judiciary, and a society with a choked or coarsened conscience. Let me read that again. That's very important, and you will see themes running through here. The decay, no greater indication of the decay of the rule of law than a docile bar, a subservient judiciary, and a society with a choked or coarsened conscience. This profound insight into the rule of law is rooted in Justice Khanna's understanding that, in his words, the rule of law is the antithesis of arbitrariness, of, as I would like to say, the arbitrary exercise of power. So although Justice Khanna identifies three key elements of the rule of law in his essay, he mostly focuses on the nature and necessity of an independent, as he says, fearless judiciary. And he doesn't say very much about the role of the bar and of the public. In my lecture today, taking my cue from Justice Khanna, I propose to elaborate on the other two as well. Justice Khanna emphasized in another essay that there is a close and complementary kinship between bench and bar, and that both must work together to prevent erosion of the independent judiciary, and with it, erosion of the rule of law. So I want to add that the public also plays a crucial role, a complementary role. And indeed, I will argue that a robust rule of law depends on everyone taking responsibility for upholding the rule of law and holding all those who exercise power accountable to it. But the rule of law is a complex notion or ideal. There's much confusion and indeed a good bit of controversy about what the rule of law means, what it requires, of whom it requires that, and why. So people, ordinary people, people say ordinary people have to obey the law. That's what the rule of law is about. It's about compliance or obedience. Or with regard to society, people say, well, rule of law has to do with order. And so in the United States, there is a slogan that we hear often of law and order, and people run political campaigns organized around being for law and order. Of the courts, it's often asked or demanded, in the name of the rule of law, that trials be fair, that access be universal, that judges be impartial, and of course, independent. Of the laws, it's often said, the rule of law requires that laws be general or prospective, that is, apply only to events that happen after the publication and the promulgation of the law. Sometimes people argue that the rule of law requires that law protect human rights or perhaps property rights. of government departments, people argue, as I've just mentioned, with respect to the Attorney General and the U.S. Department of Justice, they argue that the departments must be independent of other departments, independent of the chief executive or something like that. And each of these propositions is challenged. So my talk today falls into two parts. First, I want to say something about the nature and foundations of the rule of law. And then I want to raise three important points about the role of lawyers in upholding the rule of law. I have to say something, first of all, about my proposal for understanding the rule of law. I hope to develop and put before you what you might call a conception of the rule of law, and it has a sort of complicated structure. So let me just identify that structure first before we launch into the idea itself. First of all, the conception of the idea of rule of law identifies a central or core aim, the core idea of the rule of law. And then it works out what I take to be important, immediately subordinate principles of the rule of law. Those principles have to do with what I call sovereignty and equality, or equality before the law. But that is still to stay at a fairly abstract level. And then we have to look at the kinds of institutions and practices that give reality to those ideals, that realize them in that sense. And for those, I identify two parts, what I call legality and fidelity. And I'll explain of these all, of course. So we have a core idea, three or two core subordinate principles that are crucial to the idea of rule of law. It's required institutions and practices. And then lying behind that is a question, well, why have it? Why is it important? And so this conception also puts forward a proposal for justifying the rule of law. Okay, with that introduction, let me just say, first of all, the rule of law is a fairly complex idea. It is, however, one ideal or principle of political morality amongst others. So other different, though perhaps complementary, ideas are justice, perhaps liberty, and even democracy. Let me just say, I'll come back to this perhaps later, but the relationship between, we will talk about the relationship between the rule of law and justice towards the end of this lecture. But with respect to the relationship between the rule of law and democracy, it is important, it seems to me, to distinguish between the two of them, although to keep very clear that the rule of law is, if you will, the internal structure of democracy. Democracy would collapse of its own weight if it didn't have the hard steel structure of the rule of law giving it all of its force and strength. Perhaps I'll have a word about that later. So it's the rule of law is one ideal, not the whole of political morality, but just one ideal amongst others. Nevertheless, it's fairly complex. As I've already tried to suggest, there are a number of different component principles, and we'll have to see how they're related and ordered. It is thirdly an ideal that's realized to a greater or lesser extent in different societies. Some societies will be more robust, others less. Some will be able to strengthen their commitment to the rule of law and the institutions that realize them. Others, they may be on the way of decline or decay. The ideal is something to strive for, and it can be realized, approximated in different degrees. Finally, what's important to understand about the rule of law is that it is what I call a middle level principle. That is, while it is a principle of political morality amongst others, it serves more fundamental or deeper moral political values. So it's crucial for us to ask, well, why is the rule of law important? What good does it do, or more importantly, what underlying more fundamental political values does it serve? Now, how it serves in that way, if we answer that question, will depend very much on the nature and resources of the political society which seeks to realize it. And because the circumstances and the resources of political societies will vary a good bit, there will be certain limits on the scope and force of that ideal in different political societies. It's important to keep those features in mind. With that general thought about the structure of the idea, let's try to get some grip on the content of it. Throughout its long history, and I should say, the rule of law idea has been, seeds of it were planted very far back. I'm now writing a book on the rule of law, and the initial chapter just tries to identify those seeds, and they go back very far into ancient Greece, into other parts of the now what we call the Middle East, to the East as well. And we see those seeds blossoming and growing in various ways throughout about a 2,000, maybe more than 2,000, maybe 2,500 year history. Throughout that long history, the rule of law idea was rooted in, I think, a thought that has two parts, two closely related parts. The first part is that a political society is well ordered when its members are secured against the arbitrary exercise of power. And the second idea is that the law is well equipped to provide that kind of security because of its distinctive capabilities and instruments. So I want to articulate what I take to be the core thought behind the rule of law. And it is this: the rule of law promises protection and recourse against the arbitrary exercise of power through the distinctive modality or instruments of the law. Let me say it again. The rule of law promises protection and recourse against the arbitrary exercise of power through the distinctive instruments of the law. We can regard that as a kind of mantra. When I teach, have taught my students, I say, all right, what's the core idea of the rule of law? And they rattle it off. Protection and recourse against the arbitrary exercise of power through the distinctive instrumentalities of the law. Keep that in mind. It is not just a slogan. It articulates, or it's intended to articulate, what I take to be the core driving idea. Now, it's very abstract, of course, and we will need to find ways of making it more concrete. But to begin, let me take that articulation of the core idea and spell out the key, and articulate a little bit more the key concepts that are included in that mantra. The concepts will be the concept of power, the concept of the arbitrary exercise of power, the idea that law provides a means for protection and recourse against the arbitrary exercise of power. And then I want to say just a word about what I mean by protection and recourse. Okay, I hope you're all with me. Let's begin with the concept of power. Xenophon, the ancient Greek historian and philosopher, said, power is the action of the stronger when he constrains the weaker to do whatever he chooses, not by persuasion, but by force. That comes close. Let me try to spell out a little bit more. First of all, what's the nature of this power? Well, sometimes we talk about having the power to do something as the power to bring about some result. The power to move a stone, the power to affect the interests of other people, perhaps. So one has power with respect to other people sometimes if one can just do something that affects them positively or negatively. But the power the rule of law has in mind is a little different. It's the power of certain agents over other agents, such that the person who is subject to that power is in the power of the one who wields it. So it's power over someone, not just power to do something. And so it has a number of we ought to break this idea down a little bit more. First of all, what it does, it concerns the ways in which persons relate to other persons. In particular, the ways in which people who are agents, actors, acting with intention and purpose, the way they relate to other persons and agents. It is a capacity that an agent has, secondly. It is a capacity that agent has to control or strongly influence the practical decisions and actions, maybe also the beliefs of other agents. To have the capacity is not necessarily to exercise it. One can have power over another, even if one does not force someone to do something. It's the capacity to do so. That's the important feature here. The other crucial element for the kind of power the rule of law is concerned with is that this capacity exists in conditions of dependency and inequality. That is, the one who wields power is the one upon whom others are dependent. Now, what's often the case is that dependency and so that power is either created by or sustained by social and political structures, not just physical structures, physical features of people. Now, such power is, in the easiest way in which we can grasp it, it's like the power of a master over a servant or a slave. And that is a directly, if you will, personal or interpersonal relation. But it can also be more distant and impersonal. So we can talk about the power of a government, which is not a person. It's a complex set of institutions. The kind of power or the root of that power can be either physical strength or psychological manipulation, or a matter of offering incentives or disincentives. So that's the idea of power. It's worth saying a little bit about the scope of power that the idea of the rule of law has in mind. And here it's, I differ from a number of others who have offered understandings of the rule of law. Typically, the rule of law is limited to the exercise of governmental or ruling power. I think, however, it's very important to see that the rule of law is concerned with non-governmental power as well. So this can be interpersonal, as in master-slave, but also social or economic. One of the important centers for the exercise of power is the workplace. Employers who have the ability, the legal ability, and so the power to hire and to fire at will, gives them employers enormous power to regulate many aspects of the lives of employees in the workplace, and oftentimes aspects of the lives outside of it. That's a form of power that falls within the scope, or could fall within the scope, of the idea of the rule of law. In addition, there are centers of power that rule of law is concerned with that are international. Power is exercised between nations and by nations with respect to non-national, non-state parties in the international domain. And this is emerging just in the last decade or so, the enormous power of big data. We might call it cyber power. The power of Facebook and Google and Amazon and those institutions, where they exercise what we might call, first of all, power over knowledge that then becomes enormous amount of power over our lives. We who have been thinking about the rule of law have not paid enough attention to that, and in my work, I plan to do that. Okay. Well, what do we mean by the arbitrary exercise of that power by one or another of these centers of power? Arbitrary is a difficult concept, but what I have in mind here, the rule of law has in mind, is not that it's unreasonable or irrational, but rather that it's an exercise of power that's capricious and arrogant. It's power that says, I'm going to do it just because I can. The agent can choose to do it or not to do it at his pleasure. So military intelligence officers in the Guantanamo Bay internment camp, prison camp in Cuba, where the United States imprisoned people they arrested in the Middle East and Afghanistan and elsewhere in response to the attack in 2011. Military intelligence officers said to a prisoner there, quote, "You are in a place where there is no law. We are the law. So you might say, do it because I say so." Arbitrary exercise of power then is unilateral, one-sided. It's my will that determines what is to be done. Your will or the will of anyone else is irrelevant. And this is important, unaccountable. That is, they're exempt from giving reasons. I call this being unreckonable. They don't have to give a reckoning, and they are thereby also not controlled. So to be arbitrary is for an exercise of power to be unilateral and unaccountable. No one can assess then, no one can call for the accounting of such power. Note that the rule of law isn't necessarily unpredictable or even unreasonable. It's just unaccountable. Third, the rule of law's core idea says we need protection and recourse through the exercise of law, through the instrumentalities of law. Law is the means of protection and recourse. Law doesn't engage just any means. The rule of law doesn't engage just any means. It is focused on what law can do. But law here is not limited to fixed, predetermined legal rules. The law that I have in mind here that does its work has to be understood more broadly. Law is a set of positive norms. Positive, I mean the products of human activity, maybe legislation, often legislation, but also other kinds of human activity that give rise to law. And they are norms in the sense that they mark out what is to be done, not what is to be expected, anticipated, predicted, but what must be done. They're public norms in that they are addressed to large groups of people engaged in social interaction. What's distinctive of this law is that it relies often on formalities, on creating specific ways of doing things, of making a will, of creating a corporation, of determining guilt or innocence. And they fit together, these norms fit together into a more or less coherent system that governs the actions of officials and citizens over a long period of time. It's also distinctive of law that it works through institutions and formal processes or procedures for the application and adjudication of law. Courts are a paradigm example of what I have in mind here. Finally, law defines offices in a network of governance institutions. They define the powers and responsibilities of incumbents. Also, a distinctive feature of law is that it is deliberative in the sense that it proceeds not through commands or instructions, but through a discipline of deliberative reasoning. Law is arguable. So what Jeremy Waldron at one point says, what we do with legal norms is something like this. We don't just obey them or apply the sanctions that they ordain. We argue over them adversarially. We use our sense of what is at stake in their application to license a continual process of argument. And we engage in elaborate interpretive exercises about what it means to apply them faithfully as a system to the cases that come before him. That's what I mean by its being deliberative. Okay, finally, what do I mean by protection and recourse? Well, the rule of law is not opposed to power. It's opposed to its abuse, to its arbitrary exercise. It doesn't seek to eliminate power or even eliminate all abuse. It seeks to protect as far as possible against it, recognizing that abuse will occur. And so it also is concerned to provide recourse when that power is abused. What do I mean by recourse? Recourse are the resources and processes or procedures that victims can use to hold power accountable and gain redress for their violations. Okay, that's what the core idea is. I hope that that explains a little bit more what I have in mind. But that's a kind of target, an ambition, something to aim at. The immediately related to that are two principles that are designed to serve that, get us closer to that ideal. I'll call one of them law's sovereignty, and the other of them equality before the law. Here, one thing we should keep in mind is that, at least in part, the rule of law defines what I call a mode of governance. It is a way of exercising power. It is a set of constraints on that power and a set of enabling of that power, of ruling power, of governing power. And I want to think about the principles of the rule of law here, the immediately subordinate principles, in terms of principles that govern this or define this mode of governance. So, law's sovereignty. The rule of law says one simple thing: law must rule. Indeed, law alone must rule. The early 17th century political writer, a man called Althusius, says this about law. It's a wonderful encapsulation of what we mean by law sovereignty. He says this: law is for a city or a political community. Law is what, notice, what God is in the world, what the navigator is in a ship, what the driver is in a chariot, or the commander in an army. That's what law's like. Law, he says, law thus is over everyone. It's the superior above all, and each and every man recognizes it, law, as the superior. law's sovereignty, then, I think, can be captured not in one principle, but in three important subordinate principles: the rule with law, reflexivity, and exclusivity. Let me explain each of those. By rule with or by law, what we have in mind is that all governing power must be exercised through or by means of the law, not by means outside of the law. So when Justice Kahana was defending the principle of habeas corpus that requires that someone who is taken into custody by authorities must be brought before a formal tribunal to have the charges against him or her spelled out and provide an opportunity for responding. That's the rule of law working, governing power exercised through law. Another means of it, of course, is that the laws be articulated generally and they be prospective, that when governing power is exercised, it's through those formal features of the law. Sometimes this is understood to mean nothing more than the slogan, law and order. I think that's a mistake, because law and order often just means order by whoever happens to have the ascendancy of what looks like authority. That's a corrupted notion of law, of rule of law. Rule by law means that when governing power is exercised, it may be exercised only through the devices provided by law. The second thing that it requires, and this is really crucial, is that law governs all those who exercise governing power. That is, the law is not just for those citizens. The law is, and very importantly, the law is for those who exercise power. They must not only do it by law, they are governed by it. Oftentimes, those who say, we're in favor of law and order, what they're in favor of is that you obey the law and we don't. Law is not merely, according to the rule of law, law must never be merely an instrument for the exercise of power. Law is a constraint or a bridle on that very exercise of power. Finally, the principle of exclusivity says all governing power must be authorized or constituted by law, so that there is no domain of legitimate governing power that's outside of law's purview. It is only by way of the resources that the law provides us that governing power may legitimately be exercised. Now, rule by law sometimes puts limits on the exercise of ruling power, but it still seems to leave open the possibility that rulers could use law strictly as a tool of power. But the reflexivity and exclusivity principles constitute law's claim to be the sole sovereign, as Althusius put it, it's like God in the world. The rule of law is instinct. So that's the idea of law's sovereignty constituted by those three sub-principles. But we also should focus on those, not only those who exercise power, but those who are subjected to governing power, the subjects of law. And here the rule of law embraces the idea of equality, not equality in general, but equality in the eyes of the law. It holds this, then, that everyone who is subject to restrictions or burdens of the law is also entitled to the benefit of its protection. Everyone who is subject to the restrictions and burdens of the law is entitled to the benefit of its protections on the same basis as everyone else in the community. So just as law does not allow people to elevate themselves above the law, so the rule of law prohibits treatment that puts people outside of the law's protection. When it comes to law's protection, then, social, economic, cultural, or personal distinctions or differences don't count in the eyes of the rule of law. And thus, when the law inevitably draws distinctions and so treats people differently, the question must always be asked, well, what's so special about these people who get preferential treatment or on whom special burdens are placed? And compelling reasons must be given. And those reasons must not be demeaning to those who are excluded from law's benefits. And by demeaning, I mean they are not the kind of reasons that when given, force people to see themselves as lesser, as less than peers or equals to others. So with that idea in mind, I think we have to ask, what's the value served by the rule of law? Why do we think it's important? It looks pretty complicated, and if you think about it for a moment, it looks pretty demanding. Can we justify those demands? Can we justify commitment to such an ideal when it's going to be costly? Now, several arguments have been given for the value served by the rule of law. Sometimes people say, writers argue, that we need the rule of law in order to secure efficiency in government. Now, it's probably true that where the rule of law does not exist and there is a great deal of corruption and no one pays attention to any kind of regulations, it looks like there's going to be ineffective government. It also is true that it's possible for government to be pretty efficient in its exercise of power, that is, efficient in getting done what it wants to get done, which usually involves significant control over others. They may be able to do that reasonably well without adhering to the fundamental standards of the rule of law. We can never get a robust understanding of the rule of law if we think that its aim is merely to provide the kind of resources necessary for efficient government. More likely, people have argued quite strenuously and for a long time that what underlies the rule of law is some idea of freedom, individual freedom. And here, there are two ways of thinking about it. One is that what the rule of law serves is that it provides us freedom to do as one likes, freedom from interference from others. There's also a different notion, sometimes associated with it, but a different notion, and that is not so much freedom to do whatever one likes without interference from others, but freedom from domination by others, freedom from subjection to the will of others. That's played a big role in understanding the rule of law, and you can see why that might be attractive to someone who thinks that the core idea of the rule of law is protection against the arbitrary exercise of power. Thirdly, some people think that what really underlies the rule of law is recognition of respect for dignity and the equality of each of us in the eyes of others. That's a plausible claim too. However, my view, tentatively put forward, but I think it's important to see it. I think the most compelling account of what explains the force and scope of the rule of law and its constituent, those sub-principles I've mentioned, locates it in a source of the interweaving of three key components, all within a fourth. The first is respect for individual dignity. The second, equality understood as requiring each person to be treated as an equal. And thirdly, freedom from subordination to the will of another. Those three, dignity, equality, and freedom from domination or subordination, are important components of, but they find their place in the relationship in a deeper notion of community that I call membership. I made that up. There is no good already in the vocabulary of political philosophy, a good notion, a good term for this. So I've created the term membership. to indicate the kind of community in which respect for dignity, equality, and freedom are interwoven components. So a membership community is a fellowship of mutuality, an engagement of mutual commitment that's rooted in and really nourished by deep interdependency of people within that community, and structured by a network of mutual responsibilities. Those responsibilities that support a widely inclusive social order. Deep interdependency, mutual commitment, a network of mutual responsibilities. So members, that is, elements in this membership community, are not subordinated to any other person or group, but rather, as members, they are subject reciprocally to each other. This involves three things: mutuality, peerhood, and diversity. By mutuality, I mean each person, each member has a place and responsibilities that then fit together with those of other members. Peerhood is the idea that just as I am included, as it were, in you, you are included in me, and we stand face to face as peers. Thirdly, diversity. What I mean by that is neither you nor I lose our identities by being members of this community, because as members, we occupy the same status. Membership brings under one normative roof, I think, dignity, equality, freedom, and community. It stands alongside other important political values like justice or peace or the promotion of human rights, though it may be cognate with them in various ways. Membership, understood in this way, stands resolutely opposed to subordination of some in the community to others, and hence it's opposed to subjection of some to the arbitrary power of others. And it calls on the law to provide the needed protection against such subordination. Law is more than a convenient instrument of protection. It protects against subordination in a way that lends integrity and coherence to this community of peers that it's employed to serve. So we're faced with a further question. How can law rule? We answered the question, or tried anyway, offered an answer to the question, why think the rule of law should govern us? And the rule of law says law must rule. But the question is, how can law rule? And here I'm turning to those institutions and practices and the like that are important to realize the rule of law. The rule of law conception's answer is complex. It has two essential parts: institutions of legality and an ethos of fidelity. Let me take them in order. Institutions of legality. The rule of law is secured through an organized set of institutions that constitute and constrain, we might say, that temper ruling power. The shape and arrangement of these institutions depend on a social and cultural conditions of the political societies. But for modern polities, including the United States and India, to be sure, they include these following things. First of all, laws themselves must be general, consistent, prospective, accessible, understandable, and stable. Secondly, the institutions that are organize the administration and the enforcement of law must be, first of all, congruent with public laws. They must be manifestly impartial. And third, they must be themselves subject to review, accountability. Adjudication in particular must be independent of executive and legislative branches. And here we're bringing in Justice Kahana's very important component of the rule of law, namely the independence of the judiciary. The adjudication must also be widely accessible, universally accessible, and must respect the principles of what we in the United States call due process, more generally sometimes called natural justice or fairness in the principles of adjudication. And also, there must be a set of governmental institutions, especially those within that make and execute the law. They must be structured in such a way that power is distributed and checked. And that requires the independence and integrity of each of these. This we might, in a gesture, we might gesture towards the idea of the separation of powers. Much needs to be said about that. But I just want to summarize that this is an area where the various kinds of institutions that we bring into place to serve the rule of law can vary from political community to political community, yet they have to have the signal character of, in the circumstances to which they're addressed, they must pursue and give protection and recourse against the arbitrary exercise of power. Ethos of fidelity. Here, I want to talk about what Justice Kahana talked about as the necessary social discipline. Recall he said the decay of the rule of law is evident in the coarsened and choked conscience of the people. I want to think about this. Here's a challenge. Everyone knows that laws don't rule. Only people rule. Institutions are only as strong as the commitments of the people who give them life. So law is robust. Law can rule in a political society only when its members, its officials and rulers on the one hand, and citizens alike, only when they take responsibility for holding each other accountable under the law. That's what I call fidelity. This is an ethos because this is a mutual commitment, a set of dispositions and practices that enable people to take responsibility for holding each other accountable. So fidelity includes more than mere compliance with the law. It calls for participation of everyone in a network of accountability holding. All members, officials and citizens alike, are subject to the law, but they also have responsibility for holding each other accountable. This duty of fidelity is owed not to the law. I'm looking at the chat here. Back up. The fidelity, this duty is owed not to the law or to government, but to each other. But how is it for us to, we citizens, to exercise this responsibility of holding officials, as well as each other, but holding officials accountable? How do we do that? The only way we can do that is through further institutions and practices in which the citizens themselves can combine and fulfill their responsibilities. Amongst these are free press, important civil society organizations like non-government institutions, organizations, civil associations, unions, political parties, and I think very importantly, universities. And an important institution of fidelity is a strong and independent and rule of law minded bar, lawyers. Here I bring in Justice Kahana's concern about a robust and strong legal profession. So let me take up that idea of the role of lawyers in the rule of law. What's the role? It seems to me that lawyers have a critical role in sustaining and protecting the rule of law. The rule of law, after all, shapes and underwrites the lawyer's professional role and the lawyer's responsibility to clients and to public and to the law. Now, judges are often said to be the guardians of the rule of law, but I think equally lawyers are guardians and conservators of the rule of law. Due to their special knowledge, their legal powers, their capabilities, their social position and opportunities, lawyers are really uniquely situated to undermine the rule of law, but also they're uniquely situated to secure and maintain the law's sovereignty. There's where their crucial responsibility lies. Lawyers' practice over time inevitably shapes the law. So lawyers, as conservators, bear responsibility to take special care for law's integrity. There's no guarantee that law's coherence and justice orientation will prevail. It needs constant tending. Lawyers play a special role in maintaining law's integrity, yes, and also maintaining the public's trust in the law. Lawyers are essential intermediaries then between law and citizens and the institutions and officials of government in at least two ways, maybe three. First of all, lawyers are important to bring law to the people. Lawyers are important to enable people to exercise and protect their rights, to provide them, the people, access to the law and law's legal resources for protection and recourse when necessary. Lawyers also play a crucial role in tempering the exercise of governmental power. In the advising role, the lawyer's concern is not just with compliance, but with constraint on the arbitrary exercise of power. Lawyers, of course, must not counsel the violation of law, but especially when the client is capable of exercising arbitrary power of others. And that's not just government, but also perhaps those who exercise economic power. When they advise clients capable of exercising such power, lawyers must advise compliance with the law when the law constrains the exercise of that power. But also they're crucial for enabling accountability of the law of those who exercise power. They facilitate and participate in holding accountable officials and others who exercise power. Lawyers are an important countervailing power to the state, tempering state power with what's often fussy legal formalities. It's not surprising that political leaders are often inclined to follow the suggestion that Shakespeare has one of his characters say, first what we do is that we kill all the lawyers. They'd rather get rid of lawyers. But modern authoritarians are really much more subtle. They're not keen to kill them. The important thing is that they co-opt them and corrupt them. Because lawyers are needed to turn the law against the law and the rule of law by those who are not committed to the rule of law and democracy. So lawyers must be especially vigilant and resistant against their being used against the law. So I want to conclude with three challenges that lawyers committed to the rule of law face, or that we, thinking about the rule of law and the lawyer's role, will face. First of all, law's complexity and the problem or the worry that the rule of law just is the rule of lawyers. Here's the problem. Law is complex. Law is tricky. Ordinary citizens must be aware of and understand the law in order to guide their actions and determine and defend their entitlements and to properly hold officials accountable. However, the law is vast and complex. It's obscure and contested. It's an object of specialized study and apprenticeship. Empirical studies show that ordinary people's knowledge of the law is pretty weak. Now, Jeremy Bentham's solution was simply to make the law as simple and accessible as possible. His idea was every man his own lawyer. But I think this is naively unreasonable. It just can't be done. So is the rule of law unrealizable? No, I don't think so. But an independent bar is absolutely essential as an intermediary between law and citizens. But this raises a new challenge. Doesn't this create a new dependency, an asymmetry of knowledge between lawyers and clients, lawyers and citizens? And doesn't that create with it the potential for abuse of power? So does the rule of law really lead to a rule of lawyers as opposed to the law ruling? No, I don't think so. But this does articulate a challenge for the successful realization of the rule of law. Yes, lawyers possess significant power, but the question is the bar subject to adequate constraints on their power? And is there an effective network of accountability? Now, with respect to constraints, what we can say is, while the lawyer's activity overall influences greatly the shape, and as I said, the integrity of the law, no lawyer's decision has the kind of finality that even courts, judges' decisions have. Lawyers affect the development of the law through their participation in a process and a disciplined process of deliberation and argument over time in mainly a forensic context, but outside of it as well. So in one sense, we shouldn't worry about any decisions that they exercise as having, as it were, legal finality. However, it is true that clients nevertheless exercise a good bit of power. And for this, we must look for constraints. And in the United States, at least, I don't know the details of the Indian arrangements, but there are, in the United States, strict professional standards, many of which have themselves legal standing, legal status. So is there accountability? Well, oftentimes the accountability is either for those who are working in firms or in corporations or in the government. There is in-house discipline. And of course, there is discipline by the bar. But the challenge remains, it seems to me, because the question we can ask, is a professional code and, if you will, trust us as a discipline, are they sufficient? And we have to be continually vigilant about ensuring that this guild accountability and the constraints to which lawyers are held are adequate to shape, orient, and constrain the lawyer's exercise of power. It doesn't happen automatically. Secondly, how do we reconcile the professional obligation of lawyers to clients, the obligation of loyalty to clients, with law's sovereignty? I call this the problem of navigating the margins of legality. Here's the problem. Law is complex, and at various points, it doesn't give us bright lines. So lawyers must use careful, informed judgment to determine what the law actually requires, or permits, or authorizes. According to a common or a standard understanding of the professional role, lawyers are bound to client loyalty and bound by client's control. This is widely thought that citizens, furthermore, it's widely thought that citizens are entitled to press any legal claim within the gray area, that area in which the lawyers must exercise their judgment in determining what the law requires. And they're entitled to lawyers' aid in doing so. We call that the gray area. Moreover, the lawyer is not held liable for any harms that might come from advancing a colorable, that is not obviously illegal claim on the client's behalf. So many hold that the typical lawyer's activity involves working the margins, pushing the envelope, stretching the law to fit the client's interest. One sort of cynical definition of a lawyer is someone who's skilled in circumventing the law. Is this consistent with law's sovereignty? Now, some people argue, yes, it is, because the rule of law is served indirectly by virtue of the adversary system. Opposing counsel presents strong legal argument for clients in a public forensic context overseen by an impartial third party. And that third party is charged with refereeing the context and making a final judgment. While the lawyers are advocates, the system as a whole serves the rule of law. This argument has limited applicability, I think. It's plausible, but only when the parties and their counsel are of at least roughly equal power. And secondly, much lawyers' work is done outside of courts, outside of litigation, and even beyond the shadow of the court. Remember, rule of law's deep concern is to protect against the arbitrary exercise of power. This puts constraints, I think, on navigating those margins of legality and navigating within the gray area of law. We can distinguish three types of client or context for lawyers' work. Lawyers can be advisors for and agents for private individuals or groups in civil society. They can be lawyers of and hired by government agencies, for example, agencies in the executive branch of government, or non-government organizations, corporations and the like. I'm going to pay attention just to the first two, private individuals and government agencies. Regarding private clients, there's some plausibility to the claim that a right to the gray area, that clients have a right to the gray area, because there is an important principle compatible with the rule of law that says whatever law does not prohibit is permitted. That is, whatever is not prohibited by law is permitted by law. And this principle serves individual liberty. It enables a zone of action for private citizens free of government intervention. And this leads to a model of lawyering we might call the advocacy model, which puts a high priority on client loyalty and a significant degree of client control, of course, only within the law and the rule of law. The position of government lawyers, I think, is more difficult, and our response must be different. We have to distinguish between government agencies and officials from private citizens in three ways. One, the lawyer's client, when she's working for the government agency, is the agency or its head, and not the person. The lawyer serves the office holder as a holder of an office, not a person. So the official is due lawyers' efforts just insofar as the official seeks to act within the law that defines and constrains that office. Furthermore, secondly, what is law or lawful is not limited to what is enforceable in the court according to explicitly articulated formal law. And this is because some important activities of government agencies, especially within the executive branch, as far as I know them in the United States, they're governed by law, but they're not reviewable by courts due to various rules of deference and justiciability. So there are legal rules that are not going to be enforced by courts because they're the court's own rules about deference. But that doesn't mean that those are not rules of law. So what's lawful may not always be enforceable by courts. Secondly, departments of government are often governed not only by explicit or formal law, but what we might call informal norms and practices. In the US, there's a lot of talk amongst constitutional scholars about the unwritten Constitution, the Constitution that supports and enables, makes possible government under the written Constitution. And these are made up of conventions and practices of an informal nature. They too define limits on what government agencies and officials can do. And finally, the difference between government agencies and individuals is that government agencies and officials are not entitled to the gray area. This is because the opinions of lawyers are often, or of lawyer advisors within the government, are often secret, non-public. They're insulated from challenge from the outside, insulated from challenge in court. And because the principle, remember the principle that we found applicable for private clients, namely whatever is not prohibited is permitted, that principle does not apply to officials and government agencies. As government functionaries, their actions are legitimate only when, and to the extent that they are clearly authorized. This is a reflection of the reflexivity principles and the exclusivity principle that we saw crucial for the rule of law. Thus, there's no extra legal zone of activity or power for those who exercise ruling power. And unlike private citizens, government and its officials don't have a significant liberty interest. There is no interest in being a free government, free from government interference, as it were. And so, because of those differences, the model of proper government lawyer activity is not advocacy, but advising. The lawyer's first response, the lawyer working for government agencies, first responsibility is not to the official or the official's policies, but to the law, the Constitution, and the rule of law. Thus, the lawyer must articulate the law as it constitutes and constrains the exercise of government. Law is, for government, a constraint, not a permission slip. The lawyer's aim, then, is to enable agencies to follow the law, enable them to follow the law, not to stay out of prison, not to have a plausible defense in a court of law, or a plausible and effective defense in a court of public opinion. Thus, the official is entitled to, and the lawyer is bound to give the best interpretation of the law, rather than merely a colorable one, even when that's contrary to government policies or policy aims, and matters that are in the contested area, the gray area. In this respect, the lawyer is an agent of and a key player in that system of mutual accountability. We might call this ex ante or before the fact accountability. One last point here about lawyers' role. This has to do with the rule of law and justice and lawyers' integrity. So, even laws in legal administration consistent with the demands of the rule of law may nevertheless be unjust. They may be consistent with some derivative principles of the rule of law, but not others. So lawyers enabling the exercise of power with respect to these laws, these unjust laws, may appear themselves to be agents of injustice. The rule of law doesn't immunize lawyers from moral responsibility for their professional actions and their consequences. Lawyers do not check their membership in the moral community and its responsibilities at the office door or the courthouse door. Lawyers are morally responsible for their actions and their consequences within as well as outside the boundaries of their professional role. However, we also have to recognize that the professional role, rooted, as I've argued, and governed ultimately by the rule of law, offers substantial grounds for justification of actions that, if they were performed outside of that role, might reasonably be regarded as morally wrong. Because the rule of law has standing as an important principle of political morality. Yes, it's one principle among others. Yes, it's a principle of political morality, but it is one principle among others. And so while it can stand against and even override other demands of political morality sometimes, other times it may be defeated by them. Morality simply is not governed by determinate algorithms. And the plurality of moral values and principles does not always exist in harmony. There can be important choices and conflicts within political morality. Moral agents then are called upon to exercise mature, responsible judgment. And so a lawyer may be called upon to decide whether the demands of justice on her behavior override the clear demands of rule of law, or vice versa. In those circumstances, the lawyer's integrity is determined by her responsible exercise of judgment and by her taking responsibility for the consequences of her judgment, both when she fails to do what is ultimately right, and even when she does what's right, when there are costs for others. Integrity involves responsible judgment and taking responsibility for consequences of one's action. That's the core of lawyers' integrity. So what shall we say? In conclusion, I just want to quote a passage, a short passage from my friend Jeremy Waldron, who says, lawyers, especially aspiring lawyers, should, quote, reflect on their relation to the rule of law. This ancient ideal that is the focus of the profession's allegiance, the key to its honor, and the foundation of the dignity of the work that all lawyers do. The rule of law is a deeply important moral ideal. It's one that structures the professional role, and it gives substance and, I think, content and compelling force to lawyers' integrity as they perform their responsibilities. Thank you very much.
Thank you very much. Wonderful lecture. Now I would request Loka to present some questions that have been generated over the span of this lecture.
Yes, thank you, Anirudh. I'll present the lecture.
I request the IT department to kindly make Shloka a presenter. Right now, it should work. So these are the few of the questions that we got.
Okay, would you like me to respond to each of these? Good. I'm happy to. This is an interesting question. The rule of law ideal is not necessarily a matter of positive law. It is an ideal of political morality that lies behind the rule of law, behind positive law. Now, in some jurisdictions, there is an attempt to embed that moral notion in a constitution itself. But first of all, the notion that I have in mind here is a notion of political morality, which then guides us to think about what the structure and character of our law should be, and of our government, and what mode of governments we should have. So it is, in one sense, of natural law, which we mean principles of rational, defensible, political, moral principles that stand outside of the law. The rule of law is, in that sense, a compartment of natural law. Now, the rule of law idea doesn't itself decide the jurisprudential issue of whether natural law is incorporated into and embodied into positive law, that jurisprudential question about whether there is a sharp separation of law and morality, that jurisprudential issue is not settled by the rule of law concept itself. I think that my own view is complicated in that way. I think there are close connections between morality and positive law. But for purposes of articulating the concept of the rule of law, that issue doesn't have to be addressed fully. We have an idea crucial to the notion of the rule of law is the idea of how law functions. So I have to say something about law, but I'm talking about not universally conceptually necessary features of law. I'm talking about elements of law that are salient across a wide spectrum of our of jurisdictions. So we can appeal to a rough idea of how law works without having a full-fledged articulated theory of the nature of law, which must, of course, answer the question, does morality play a role in it? For purposes of this discussion, I want to set aside that and say, however that issue goes, here's a conception, here's a very important conception of political morality, of a portion of political morality. And we have to take that seriously. And that makes demands on our positive law in the way that justice makes demands on our positive law.
Look to the next question, please.
Just a second.
Try pressing the arrows.
Yeah, just a second.
But lost the PPT.
Is my screen visible?
No. It's visible now. Yeah, keep it like that. Professor, this is the other question.
Yes, wonderful question. I'm very keenly aware that the rule of law makes sense only in certain kinds of political society. If you will, there must be certain conditions in place to make it plausible to think that there is something like rule of law appropriate as an ideal for that society. Certain conditions have to be in place. Otherwise, the ideal doesn't make any sense at all. And as societies, when we move from societies that are very closely interdependent, societies that are small and depend on close relationships, constraints other than law might do the work of limiting the arbitrary exercise of that power. The rule of law is concerned with arbitrary exercise of power through law. And it might turn out that there are societies in which, because of the internal structure of them, there are ways to temper and keep within limits the exercise of power such that it doesn't become arbitrary. So so in answer to your question, what we might be able to identify in certain societies are devices institutions or means that serve protection against the arbitrary exercise of power that are not distinctively formally legal. That, in that case, I would say, well, the rule of law doesn't play there, but there are other means for protecting against the arbitrary exercise of power. It's in those societies where the relationships are less intimate, where the internal and informal practice elements are more stretched out, that law plays an important role in ordering that society, and in particular, when the ordering of that society calls upon certain group to exercise governing power through that law over that society, then the rule of law has room to play. My view is there may not be rule of law in certain primitive societies, depending on how we understand them. There may be, however, protections analogous to protections of law under the rule of law that do a similar job.
Okay, Professor Sloka, can you move to the next question?
That I hope I've answered that in some detail. My view is that sometimes the rule of law is understood to be a matter of how various government institutions are structured. If you go back to the situation that institutions that I'm most familiar with, the idea of separation of powers, right, within a government, so that the various powers of government, executive, legislative, judiciary, are in a relationship of constraining each other, holding each other accountable. It looks like that's a matter of institutions. And institutions play, as I've argued, a really important role, but institutions have no flesh and bones, no spirit, if we don't populate them with people committed to the rule of law. So what's really crucial is that there be not only institutions, but people who are committed to holding themselves and each other and the various institutions, the other institutions, accountable. So what's important are people who populate those institutions, who are incumbents in roles in those institutions, so politicians, public authorities. But my view is that that is only a small part of what the rule of law calls for. And if there's anything really distinctive about the notion of rule of law that I've argued for in that little paper I sent you and elsewhere, is that the rule of law can be robust in a political community. Law can actually rule only when there is a society-wide ethos of fidelity, where each of us takes responsibility to the extent that's possible for us. Each of us takes responsibility, one, for commitment to the rule of law, but also responsibility for holding each other accountable to it. So it's the public, if you will, that in my view, plays a crucial role in a robust rule of law. Lawyers then becomes absolutely critical mediaries, because we can't do it ourselves as individuals. Lawyers are not the only intermediaries. What we need are other institutions, like maybe political parties, maybe institutions or organizations of civil society. We need to find some way of organizing and cooperating together in this task of holding our political officials and our institutions accountable to the law. But a crucial intermediary there are lawyers. Lawyers, because they enable the rest of us to understand what the law is, such that we can hold politicians and public officials to that law. They can help us find the other resources of the law to put that pressure on political officials. And they, when they are lawyers within the government, they play an absolutely crucial role to determine, to tell forcibly, to put it differently, to enable those political officials to do their job. Enable them to understand the law, enable them to act within the law. It's a crucial role of lawyers when they're outside of the government to act as intermediaries between citizens and public officials. Within the government, it's crucial that they be the spokespeople for the law. They are the those who hold, as I say, hold accountable before the fact, not after they've done something wrong, but before the fact. So all of them, yes, all of them.
Next question, Shloka.
Oh boy, yeah. Data elephant, I like that. I haven't heard that phrase, but it's an apt phrase. Right now, the big data, the artificial intelligence manipulators exercise an enormous amount of power over your daily life and mine. And it's getting more and more that way as we become more and more dependent on WebEx. And all those devices, I don't know how far they've got into India, but all those devices that allow us to, by voice alone, turn on the coffee pot and the television and the radio and all that kind of thing. These devices and our phones give an enormous amount of data to the various platforms to track us. We are under what some have called surveillance capitalism. The surveillance is exercised not by governments, by non-governmental sources of power. And we have just begun to think about how to put them within the limits of law. In my view, the rule of law has something important to say, because even if they're really nice guys, I mean, maybe Zuckerberg is a wonderful man. Doesn't matter. The fact is that Zuckerberg and Jeff Bezos and all the rest can have the capacity to exercise arbitrary power over us. It's that power, not their character, that we worry about. Just as we say, yes, those who exercise governmental power, we want you to be of good character. In fact, we can't have a functioning government unless you have good character. Parentheses, we have a good example of that going on right now in the United States. But if, in any case, if we need good character, but we're not going to depend on your good character. We're going to institute structures of accountability. We need those for big data, for the big data elephants. And we haven't begun to do that. And it's a really interesting question to which I don't have an answer. Whether the law has the resources to do that. I don't know. I think we are in various places around the country, in various areas, and the international level as well as the national level. We're working at that, but it's a new field for the rule of law, a new field for law. Probably the most challenging one, other than trying to address climate change, which I think is the paramount one. Great question. I wish I had an answer. There's no simple answer, but let me just say this: work at it. Work at it. I'm out of the question. I'm out of the picture. I'm too old. All I can do is urge you to work at it, because that's where much of our international and national survival is going to depend.
To the last question, Shloka.
Oh, immigration. Of course, I've only given you a tiny seed of the idea of membership. In another project, I'm developing at some length this idea of membership, the idea of a community of equals. And there, I spend a lot of time thinking about the problem of immigration or migrants. And I can't give you the full story, but it does seem to me that one of the key worries that anyone who takes the notion of community and those things that enable community to have coherence, take them seriously, what you have to worry about deeply is how are boundaries of that community determined, and how is access across those boundaries determined. And it's a real I call it a kind of characteristic defect of any community that it wants to be insulated and isolated, because we need to feel a camaraderie with each other, and yet that has deeply problematic consequences for what we do that affect other people. And so we have to pay attention to the ways in which this necessary recognition of the importance of attachments, and so our own community, can so distort our views that we're unable to take into account the needs and concerns of those who are outside, and to whom we may have real responsibilities because of the impact of our action as a community on those who are outside. There are humanitarian concerns that we must always take into account, and there are concerns about what we do. I'm thinking we as in the United States, you can think in your own terms, what we do that has an impact across the world, where that impact imposes on us a responsibility to do something about how we've affected those people. So whenever we're thinking about membership and membership as a community and the attachments that are necessary to make that community work, we also have to think about how we define those boundaries and who we let in. It's a large question, an extremely important question. I'm glad you asked it. That's another book.
Thank you so much, Professor. Hannibal?
Yes, thank you, Professor. And if I may, I just have a small doubt of my own. Regarding the ideas that have been connected in these strings of questions, the idea of morality, that when a person or an individual or an entity has leverage to demand of a certain state or an institution a greater attention towards itself, how does it affect the ability of the institution to react to it in a fair and just manner? For instance, I'd like to point out, if today Apple wants to stop selling iPhones in the US, the US is going to panic and try to get a reasonable tariff back. The Mexicans state, there isn't going to be a greater leverage. They're at the mercy of somebody else. So I'd like your views on this kind of magnitude that is there in states and institutions of those kind.
Yes. I apologize. You broke up a little bit, so some of the continuity I may have missed. So let me just see if I answer the question I think I heard. Okay. How do we actually hold them accountable? What kind of constraints do we put on them to which they can then hold them accountable? When we're talking about, I take it you have in mind big data companies and platforms like Facebook or Google. Is that right? Yes. Okay. It does seem to me that we've got an international coordination problem. That is, when it comes to those platforms, we as a particular nation can do some things to constrain, but to make to put such centers of power under control adequately, where those centers of control are international in scope, we're going to need international cooperation. And there will be things, projects, policies that we adopt as a nation, one nation adopts, that could work against doing so adequately around the world. I think the same, controlling Facebook is like controlling COVID, COVID-19. If we can't work together with such an internationally powerful, can I call them both viruses? Viruses. If we can't do that, we will be trying to save ourselves irresponsibly and perhaps, probably likely, ineffectively, unless we engage in serious interaction across boundaries. So the rule of law, just to conclude this, the rule of law is really important in the context of international relations. We have said nothing about that, of course, but international relations as well. And that's a fraught and controversial area, but extremely important for our thinking about the rule of law. Thank you.
So much for those answers. Due to the paucity of time, we cannot read questions. And I would like to conclude this event by asking our registrar sir to give the vote of thanks.
Hello. Seems like there's a small technical issue. Sir? So they're unmuted, but it's not audible. It seems there is a technical issue. I take the privilege to thank each one of you on behalf of university. I thank Vice Chancellor sir and all other authorities for providing such an opportunity. I'm very sorry that Lister sir could not join. It seems there is a technically he's still trying, but somehow we can't hear. I'm very sorry for that. If you have any other questions, kindly drop us. You have our email ID, and thank you so much. We thank Professor Gerald Postema for his wonderful lecture, and also for consenting to deliver the lecture with just a small request. Thank you so much, sir, and we wish you a good day ahead. Thank you so much, everyone.
Thank you all. I'm very glad to have this opportunity.
It's our pleasure, Professor.